Sorry for the delay, Your Lordships. One of the teams have not arrived. So as soon as they arrive, we'll be starting the session.
Okay. What is it?
IMC 114, where are the other two members? They haven't joined yet. You can unmute and speak. So that won't be a problem.
They are here. Please wait. Some network issue. They will join soon. Sorry for the inconvenience.
Okay, okay. So team IMC 114, what would be your time apportionment?
Pardon?
How would you like to divide your time between the speakers and the for the rebuttal?
It's 15. Can you hear me?
You're not audible. You can just put it in the chat.
Can you hear me right now?
There's some echo. Is it okay if you can just type it into the chat? So you'll want to divide 15 each for each of the speakers and the rest 15 for rebuttal. Is that what you'll want to? Hello, am I audible?
Can you say it once again? I'm sorry.
So for team IMC 114, the speaker 1 has 15 minutes, the speaker 2 is 15, and for rebuttal, it is 15 minutes.
Yes, yes.
Okay, thank you. One more. So judges, I'm very sorry for the delay. So there were a few participants who had to join. So that's the reason. So good morning, everyone. It is our esteemed privilege to have with us our judges for the quarterfinals. For the attention of the judges, we have team IMC 113 composed of speaker 1, speaker 2, and the researcher representing the petitioner. And we have team IMC 114 composed of the speaker 1, speaker 2, researcher for the respondents in the case. I hope the teams are familiar with the rules. Both teams have 45 minutes each for their presentations. Team 11 IMC 113 speaker 1, you have 20 minutes. Speaker 2, you have 23 minutes, and your team will have 2 minutes for rebuttal. And when it comes to team IMC 114, speaker 1, you have 15 minutes. Speaker 2, you have 15 minutes, and your team will have again 15 minutes for rebuttal. There will be a warning given for half time, 5 minutes and 1 minute left, and time over in the chat box. Please ensure that you monitor your chat box correctly. You may only continue speaking with the permission of the court. Team IMC 113, you have submitted your compendium. For the display of the same, the speakers may request the court officer with the permission of the court. We will also be going live. This whole competition will be live. So I hope you all don't have any inconvenience regarding the same. So the speakers of IMC 113, you all may request the court officer for the presentation of the compendium.
Speaker 1 of team IMC 113. Shall I start with the compendium? Sorry? Shall I start with the compendium? Should you start with the compendium? Yes. Yes.
Okay, so in that case, shall we start with the presentation? If the lordships are ready, I would like to invite the first speaker for the petitioner to speak.
Yes, please.
Yes.
So speaker 1 from IMC 113, your time starts now.
Greetings to the bench. The council seeks permission to address your lordship and your ladyship collectively as a lordship.
Yes.
Much obliged, your lordship. The council seeks permission to commence the pleading.
Please, please.
Much obliged, your lordship. If it will please this honorable court, the council is appearing on the behalf of the petitioner in the matter of Octa Limited versus owners and parties interested in Moonlight. The council would be addressing the first and second issue and would be taking 20 minutes of the court's precious time, whereas the co-counsel would be addressing the third, fourth, and fifth issue and would be taking 23 minutes of the court's precious time. And we most respectfully reserve 2 minutes for rebuttal. The council is appearing before this honorable court under the jurisdiction of Section 3 of the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. If the lordships are well versed with the facts of the case, the council would like to proceed with the argument.
Yes.
Please go ahead. Yes.
Much obliged, your lordships. The claimant, Octa Limited, chartered respondent's vessel Moonlight for transporting cargo to the west coast of Indo. The vessel was docked at the Deen Dayal port within the Admiralty jurisdiction of this port. The charter agreement and clean fixture stipulated that the vessel should only travel between safe ports and not enter war zones. It also stated that the parties shall resolve all disputes through arbitration at Lloyd's London. During the voyage, the vessel encountered bad weather and listed 35 degrees to the starboard side, due to which the master of the vessel ejected around 500 to 600 metric ton of methanol cargo. During the survey, the claimants, fearful of cargo loss, petitioned the court for an arrest of the vessel, which was eventually freed after the owner provided security. When the claimants requested the cargo to be released, the owners resisted, claiming they were obligated to pay general average security for the general average previously stated by the ship owners. The claimants contended that the ship was unseaworthy. However, the insurer of the claimant provided security for the general average and the cargo was released. Thus, the present case. The facts in greater details would be dealt as the council proceeds with the issue. The council seeks permission to proceed with the first issue in hand.
Please go ahead.
Much obliged, your lordship. First issue being, the exercise of admiralty jurisdiction by the court is valid in view of the arbitration clause in the charter party. In this regard, the argument of the council would be twofold. Firstly, the charter party agreement cannot supersede the jurisdiction of the court. Secondly, that the arrest of the ship comes within the jurisdiction of this court, notwithstanding anything written in the charter party agreement. As the lordships are well aware that the dispute in the instant case refers to non-agreement of the charter party terms. Therefore, the petitioner has approached this High Court. It is humbly submitted that the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017 unifies marine claims, Admiralty jurisdiction legislation, including judicial action such as ship arrest. In the instant case, claimant is the charterer of the vessel named Moonlight, which is the defendant in the present case, a seagoing vessel flying the flag of Indo. The owners failed to fulfill their responsibility to perform their part of the agreement with regards to taking due care of the cargo by jettisoning 650 metric ton of methanol from the cargo and thus damaging the goods. According to Section 4F of Admiralty Jurisdiction and Settlement of Maritime Act 2017, the High Court may exercise jurisdiction to hear and determine any question in a maritime claim against any vessel arising out of any loss or damage to or in connection with any goods. Arbitral tribunal does not have the power to arrest a ship. In this case, the judgment will never be equitable. This question of law can't be decided, and it's paramount to our essential interest that question of arrest of vessel can be adjudicated before proceeding to arbitration. Therefore, Your Lordship, if you could refer to page 129 of the compendium, paragraph 57. Are you with me, Your Lordship?
Yeah, which paragraph?
Page 127, page 129, paragraph 57.
Okay, fine.
Are you with me, Your Lordship?
Yes, please.
Much
Yes,
obliged, Your
yes.
Lordship. In the case of JS Ocean Liner LLC versus MV Golden Progress case, it is well established that the arrest of the vessel is a right in rem. Right in rem is non-arbitrable. Therefore, the petitioners cannot approach for arbitration in London. In the same case, it was held that because the dispute between the parties fall within the scope of an arbitration agreement entered into between them, does not ipso facto preclude one of them bringing the action in the High Court and procure the arrest of the ship or otherwise proceed with the action. Civil court jurisdiction is not ousted even in a case where there is an arbitration agreement. In remedy available to a claimant is not defeated by the fact that the claimant may have agreed to refer to the disputes to arbitration. As a result, even though the parties have agreed to arbitrate in a foreign country, the Indian courts have the authority to detain the ships. Your Lordship, Section 5 of the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017 talks about the arrest of vessel in rem. According to this section, the High Court may order arrest of any other vessel for the purpose of providing security against a Maritime Claim Act. The Lordships, in the case of Altus Uber and others versus Seam Offshore Redry AS and others, the court held that the Admiralty Jurisdiction Act 2017 is silent in the case where the arbitration proceeding can also be filed, and thus no procedure is laid down in the Act 2017 regarding the arrest of the ship if the arbitration proceedings are already in progress or are yet to begin. So, Your Lordships, in this case, the court relied on the Golden Progress case and granted the power to the Admiralty courts to arrest a ship for security. With regards to this case, it can be concluded that relying on common law principles laid out in various judicial pronouncements, the arrest of the ship as security is valid and allowed. Therefore, drawing analogy from the cases, the arbitration clause in the charter party of the exercise of Admiralty jurisdiction by the court is valid. If Your Lordships does not have any further questions, the Council would like to proceed with issue 2 in hand.
You say that the arbitration clause stands with the arrest of the ship, right?
Indeed, Your Lordship.
Yes, that is legal, and that exists in this already. There is charter party. There is already a condition that the ship shall not voyage to any country that where a political disturbance or any other problem is existing. So whether it comes under the arbitration.
Indeed, indeed, Your Lordship.
Yeah.
Your Lordship, can you please repeat your question?
The question is not clear, sir.
Sorry, am I audible?
Yes, sir, you are audible.
Yes, yes.
Okay, the arbitration in London resolving all the disputes between the claimants and charter party and owners, right?
Indeed, Your Lordship.
Okay, and does it applicable in this regarding these facts of this case?
Your Lordship, both the parties, the charterers and the ship owners, mutually agreed to go to the unrest area.
Okay.
And yes, Your Lordship.
Yes, please carry on.
Indeed, Your Lordship. Your Lordship, in the instant case, the master of the vessel jettisoned 650 metric ton of methanol cargo due to the bad weather and not because the ship sailed to an unsafe port. Your
Yes.
Lordship, in the case of Union of India versus Chenia Campania Naveria, it was held that heavy or bad weather cannot be equated to perils of the sea or act of God, because that is only a normal incident of a sea voyage. Bad weather and heavy rains are not matters which are extraordinary in the sea voyage. Your Lordship, the least expectation from a well-built vessel is to be able to meet bad weather conditions. If there is a vessel which is able to face an unexpected event, then we can say, Your Lordship, if there is a vessel which is not able to face an unexpected event, then we can say that the ship owner did his due diligence, made the best ship. But because it was an extraordinary circumstance, the ship could not meet those extraordinary circumstances. But Your Lordship's bad weather is the most expected event that can occur in a voyage. The and a vessel built for a voyage was expected to face bad weather and perils in its original course. Your Lordship, since the vessel could not stand the bad weather, it clearly suggests that the vessel was unseaworthy and there was a breach of the agreement on the part of the ship owners.
Yes. Okay.
Indeed, Your Lordship. If Your Lordships don't have any further questions, the Council would like to proceed with the second issue in hand.
Yes, please.
Much
Yes.
obliged, Your Lordships. Second issue being, the declaration of general average is legally unsustainable if the respondent's vessel was unseaworthy. In this regard, the argument will be threefold. Firstly, the rule of general average is applicable to the dispute in the present case. Secondly, the general average can be declared in case actionable fault is attributable to the ship owner. And thirdly, upon analyzing rules and case law, it's clear that in the instant case, declaration of general average is not sustainable. Your Lordship, general average is a principle of maritime law that essentially establishes that all sea cargo stakeholders, including owners, shippers, etc., evenly share any damage or losses that may occur as a result of voluntary sacrifice of part of the vessel or cargo to save the whole in an emergency. The basis behind this principle is that the party who has suffered extreme financial loss in order to save property belonging to others has the right to be compensated for such loss. The York-Antwerp rules control general average. If Your Lordship could refer to page 4, line 2 of the moot proposition.
Yes.
Are the Lordships with me? Are you with me, Your Lordships?
Yes, please.
Indeed,
Yes,
Your
yes,
Lordship.
yes.
It's clearly stated here that the charter party is an NYPE form. Since the charter party is an NYPE form, clause 33, subclause A of the NYPE can be applied in the instant case. It talks about the applicability of Hague-Visby rules. The Hague-Visby rules is a set of international rules for the international carriage of goods by sea. Your Lordships, in the case of Elise 1954 and another, the vessel had been unseaworthy before and at the beginning of the voyage. Ship owner must have complied with their obligation to provide a seaworthy ship at the commencement of the voyage. In this case, due diligence to make the vessel seaworthy had not been exercised by the owners because the master had failed to exercise reasonable skill and care, which was a breach of the owner's obligation under Article 3, Rule 1 of the Hague-Visby rules. So the defendants were not liable to contribute in general average. Your Lordships, in the instant case, since the vessel was unseaworthy, the vessel experienced bad weather, due to which the vessel listed 35 degrees to the starboard side, and the master of the vessel jettisoned 650 metric ton cargo of methanol, due to which the claimant suffered cargo loss. There was a breach of the owner's obligation under Article 3, Rule 1 of the Hague-Visby rules to exercise due diligence to make the vessel seaworthy before and at the beginning of the voyage. The breach amounted to actionable fault within the meaning of York-Antwerp rule. Your Lordship, it's a well-settled rule of actionable fault that loss of cargo would not have taken place if the ship owner would have provided a seaworthy vessel. The ship owner is the wrongdoer, and the person has to try all available methods to prevent or minimize consequences of their own wrongdoing. The ship owner cannot be allowed to seek compensation for services done or the indemnification for costs incurred in attempting to safeguard property that had been jeopardized by their own tortious behavior and was their own responsibility to save. Your Lordship, in the instant case, the ship owner provided an unseaworthy vessel. The ship owner, by their own fault, occasioned the peril.
Counsel,
Yes,
is
Your Lordship.
unseaworthiness defined anywhere? Is unseaworthiness defined anywhere? How can you define unseaworthiness?
Your Lordship, unseaworthiness is not defined anywhere in the mode proposition. Although, Your Lordship, if you could refer to page 205 of the compendium.
205 of the compendium. Okay.
Your Lordship. Your Lordship, are you with me?
Yes, yes.
Yes. Your Lordship, in the case of Elise 1954, it was clearly held that because the owners did not exercise due diligence to make the vessel seaworthy, there was a breach under Article 3, Rule 1 of the Hague-Visby rules. Because Your Lordships, under Article 3, Rule 1 of the Hague-Visby rules, the ship owner is obligated to provide a seaworthy vessel, a vessel which is able to meet are able to meet bad weather conditions and can peacefully sail throughout the voyage. But since the ship owners did not practice due diligence, the vessel was unseaworthy, and Your Lordship, in this case, the defendants were not liable to contribute in general average since the vessel was already unseaworthy. Your
Okay,
Lordship, the
Counsel.
counsel will be dealing in a greater length in the coming arguments about the unseaworthiness.
Okay.
Much obliged, Your Lordships. Your Lordships, in the instant case, the ship owner provided an unseaworthy vessel. The ship owner, by their own fault, occasioned the peril that gave rise to the claim. To minimize the consequences of their own wrongdoing, they jettisoned 650 metric ton methanol in order to save the remaining cargo. Therefore, allowing the ship owner to obtain general average from the charterers would be manifestly unjust. Thus, the general average expenditure was caused by the ship owner's actionable fault. Your Lordship, due to the bad weather, the master of the vessel jettisoned 650 metric ton of methanol, which resulted in the claimant suffering cargo loss. In Union of India versus China Campania case, it was held that heavy or bad weather cannot be equated to perils or act of God, because that is only a normal incident of sea voyage. Bad weather and heavy rains are not matters which are extraordinary in a sea voyage. The least expectation from a well-built ship is to be able to meet bad weather conditions. If there is a vessel which is not able to face an unexpected event, then we can say that the ship owner did his due diligence, made the best ship. But because there was an extraordinary circumstance, the ship could not meet those extraordinary circumstances. But Your Lordship, in the instant case, bad weather is the most expected event that can occur in a voyage. And if a ship cannot face bad weather conditions, it is due to the vessel being unseaworthy. A vessel built for a voyage was expected to face bad weather and perils in its original course. Lordships, in the instant case, the ship's unseaworthiness was caused by a duty to implement due diligence. Hence, the ship owner cannot limit their obligation. Regular maintenance by the master, including essential inspections, replacements, repairs, while the cargo wasn't their responsibility, would have satisfied due diligence. Your Lordship, the vessel's owner failed to exercise due diligence to make the vessel seaworthy at the start of the voyage. The English Commercial Court recently ruled in the case of Cape Bonny that neither the Chinese cargo interests nor their subrogated underwriters were liable for the cargo's proportion of GA. The vessel was unseaworthy and the owners could not discharge the burden of proof that they or their agents exercised due diligence before and at the beginning of the voyage. Thus, the
Please make
general average expenditure.
Thing of exceeded.
Yes. The ship itself is unseaworthy. It is clearly mentioned in the problem. And whether this general average applicable if a ship is unseaworthy.
Your lordships, it's nowhere written clearly in the moot proposition that the vessel is unseaworthy. It's a condition if the vessel is unseaworthy.
Because a ship always faces different kind of unexpected weather conditions. That it
Indeed,
is.
your lordship.
Yes. So general average itself is to save the ship and other cargoes and the crews from bigger casualties, to reduce the casualties. I mean, to reduce the loss. So if the weather is unseaworthy, whether the general average is applicable, that is my question.
Indeed, your lordship. Your lordship, if the vessel is unseaworthy, then that general average is not applicable. The petitioners are contending this.
Okay, is it held anywhere? Any judgments or anything you have to?
Indeed, your lordship, the council did talk about the case Ellis 1954, which is mentioned in the compendium.
Okay.
Your lordship, in that, yes, your lordship.
Please carry on. Go ahead. Yes.
Much obliged, your lordship. Your lordship, thus, the general average expenditure was caused by their actionable fault and they were unable to recover general average contribution from the cargo interests. Therefore, on the basis of general average principles and the York-Antwerp rules, the respondents are responsible to pay for the loss and subsequently the declaration of general average is legally not sustainable. If the lordships don't have any further questions, the council would like to seek permission to invite the co-council to address third, fourth, and fifth issue.
Yes, counsel.
Much obliged, your lordship. Your lordship, it was an honor to plead before this court.
Greetings to your lordships. If it may please this honorable court, the present council would like to begin.
Yes.
Yes.
Much obliged, your lordship. Your lordships, the council will deal with issue 3, 4, and 5. Now, the third issue present before this court is whether the court, considering this issue, would be bound by sanctions imposed by a third country. A little background, your lordships. The claimant Octa Limited insured cargo from an insurance company and also received a letter of subrogation, which basically gives it the legal rights to pursue insurance claims against respondents. Now, interestingly, this insurance company is also been enlisted under SDN list. Now, your lordships may ask, what is an SDN list? SDN list stands for Specially Designated Nationals List, which is issued by Office of Financial Assets and Control in the US. Your lordship, to put it like this, SDN list is locally issued by an enforcement agency in the US, which has no jurisdictional authority. So the question before the court is, why should this SDN list affect the jurisdiction of this court in India? Your lordship, these SDN list is a secondary sanction with no jurisdictional link, which is imposed unilaterally and is meant to deter a third country from transacting with the sanctions target. In 2002, UN General Assembly adopted a resolution calling states not to recognize such unilateral coercive economic measures to which India was a party to. Your lordships, India itself has argued that such unilateral sanctions should be eliminated as it infringes upon a country's right to economic and social development. Let's your lordships, for the sake of the argument, let's assume that tomorrow USA's enforcement agency declares a company as big as Amazon as imposes a sanction against Amazon. Let's say, for the sake of the argument. So now, does this mean that India should prohibit all business dealing with Amazon? Does this mean that the value of Amazon has been impugned all over the world? Certainly not. So, your lordship, Moreover, as long as there does not exist any comparable sanctions in India to prohibit the citizens or companies from doing business with the targeted party, these sanctions such as SDL lists, are merely extraterritorial application of domestic laws of a third country, which is US in this case. Now, in the instant case, Your Lordships, the court needs to consider that such unilateral imposition of sanctions in the absence of any judicial scrutiny makes it an arbitrary exercise of power on the part of the sanctioning state. These sanctions, more often than not, serve to further a state's foreign policy objectives and nothing more than that. It is also pertinent to note that these sanctions raise difficult questions in terms of restrictions on the exercise of state jurisdiction, especially where there is no jurisdictional link. The legal scrutiny of such secondary sanctions is desirable. So, coming to the council's argument, this council contends that this court is not bound by sanctions imposed by a third country, which is US in this case, unless there is any comparable sanctions in India to prohibit such sanctions. Now, if your lordship do not have any questions, the council would like to proceed to the next issue, that is issue number 4.
Okay, can parties to a maritime contract can choose any country at arbitration? Can they choose any country or any forum to be arbitrated any of the issues raising during this contract? Is it possible?
Indeed, your lordship, the parties are governed. The arbitration is based on the very principle of party autonomy, which basically confers the parties the right to arbitrate and choose their choice of seat and venue. So the parties to a contract can decide which laws govern their contract. If that answers your lordship's question.
Yes, please go ahead.
Moving on, much obliged, your lordship. Now, for the fourth issue, the council contends that the court cannot adjudicate on the rival claims even if the alleged damage occurred within the territorial waters, as the rival claim of GA contribution has to be necessarily settled in arbitration at Lloyd's London. Your lordship, for the sake of clarity, the council would like to say that here original claim was raised by Octa Limited, which was claim of short delivery of cargo, against which the respondents, that is MV Moonlight, raised a rival claim demanding GA contribution. Now, the council would like to deal this issue in a twofold manner. Proceeding to the first limb of the argument, insofar as short delivery of cargo is concerned, the plenary power of this honorable court enables it to adjudicate on the claims of short delivery of cargo. If your lordship may refer to para 8, page 3 of the moot proposition.
Okay.
Yes.
Your lordships, it is evident that after the jettisoning of the cargo, the survey report found that the delivery of cargo was actually short of 650 metric ton of methanol, not 500, not 600, but 650 metric ton of methanol, as opposed to what the respondents contended. Now, in the instant case, it relates to the principle of admiralty jurisdiction given under Section 3 of the Admiralty Act of 2017, which applies to all vessels, and I quote, applies to all vessels operating in Indian territorial waters, regardless of the owner's location or domicile. Your lordships, meaning thereby that the vessel Moonlight is in the jurisdiction of this honorable court. Now, on the account of short delivery of cargo, it is argued that by the virtues of power vested in the court under Section 4, Subclause D and Subclause F of the Admiralty Act 2017, the petitioner's claims of short delivery of cargo can be adjudicated upon by this court. This honorable court has the jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of loss or damage caused by the operation of the vessel. The council would like to draw your lordship's attention to the landmark judgment of MV Elizabeth versus Harwan Investment Trading. If your lordships would refer to page 241, para 66 and para 67 of the judgment. in the compendium, page 241.
Okay.
Page 241 of the
Lordships,
compendium, right?
yes, your lord, indeed, your lordship. Page number 241, para 66, 67.
Yes. Okay.
Now, your lordships, in this landmark judgment, it was held that the High Courts undoubtedly possess jurisdiction over claims of cargo movement and that the power of the courts is unlimited and plenary unless it is expressly or by necessary implication curtailed. Your lordship, moving to the other limb of the issue, it is argued that the adjudication of GA contribution is dependent upon the principle of party autonomy and has to be necessarily settled in arbitration at Lloyd's London. It is pertinent to understand that this court has the authority to decide on maritime claims only to the extent of short delivery of cargo, but not to the extent where it can also adjudicate on the issue of GA contribution. Your Lordship, in the Charter Party Agreement, specific reference has been made to the arbitration clause by use of expression, and I quote, for the benefit of this honorable court, I'm reading that any dispute regarding GA has to be settled in arbitration at Lloyd's London, as given on page 4, para 10, line 3 of the Mood proposition.
Yes, yes.
Your Lordship, any dispute regarding GA has to be settled in arbitration at Lloyd's London. Now, on a plain reading of this arbitration, of this arbitration clause in the Charter Party Agreement, it can be clearly understood that there is no manifest inconsistency or insensibility. The intention of the parties was very clear that the disputes relating to GA arising thereunder should be resolved in arbitration according to the clause in the Charter Party Agreement. Your Lordship, the Council would also like to emphasize that arbitration is based on the principle of party autonomy, which says that the party to a contract have the freedom to determine the applicable law to govern their dispute. It is pertinent that the court considers the independence given to the parties to choose the venue of the arbitration to settle while adjudicating upon the rival claims of GA contribution. In the instant case, the parties have mutually agreed that the venue of arbitration shall be Lloyd's London. Now, considering this agreement, the parties having Lloyd's London as the venue of arbitration had the intention that they should be excluded, all the other courts should be excluded. Now, wherein the arbitration clause is already stipulated, your lordships, in the Charter Party, it should supersede and should be given priority at all times, because party autonomy is the brooding and guiding spirit of arbitration. So it is pertinent that the exercise of admiralty powers should be limited to only where parties' agreement is unenforceable by any standard, which is not the case in the present instant. If your lordships have no further questions, the council would like to proceed to the fifth and the last issue.
Yes, carry on.
Much obliged, your lordships. Last issue puts across a question that do the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitrable? Now, for the fifth issue, the council argues that the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitrable. Arbitration Act in itself, in its provisions, recognizes that disputes on certain subject matters are not capable of being arbitrated. Your lordships, although these subject matters have not been enumerated or categorized in the Act itself, but the courts of India, by virtue of their judicial pronouncements over the years, have formulated principles of non-arbitrability. The very first instance is the apex court in the landmark judgment of Booz, Allen and Hamilton versus SBI Home Finance, held that an action in rem is unsuitable for arbitration and thus is considered as non-arbitrable.
Which judgment?
also
Excuse me, counsel.
Citation.
Booz, Allen and Hamilton versus SBI Home Finance Limited. Your lordships, it was the judgment was
Counsel, the
decided in
citation.
2011. Your lordships, it was presided over Justice J. Ravindram and Justice Panchal. It's a Supreme Court case decided over by Justice Ravindram and Justice Panchal.
Yes.
In 2011.
Yes.
Okay.
So it was laid down by the court that all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals, being unsuited for private arbitration. Now, your lordships, it is important to understand that an action in rem determines the personal rights and interests of the parties listed in the case. But actions in rem are aimed against a property and determine the party's rights exercisable against the world at large, the general public. It has to be understood that the activities that impair the rights of the third parties in specific situations are prohibited from arbitration. But since actions in rem are not private disputes, your lordship, actions in rem are exercisable against world at large. Thus, they are considered as non-arbitrable. Now, mutual adjudication of the disputes by way of arbitral tribunal will bear no effect and thus would be impermissible in cases where the subject matter of the dispute affects the third party rights.
What are the, excuse me, counsel, what are the situations or what time can we exercise action in rem? You said that it is for example, just like salvage or anything like, what are the situations that an action in rem can be exercised?
Your lordship, in the instant case, here the action in rem refers to arrest of vessel. Now, an arrest of vessel is an inherent action in rem. Action in personam here would be, let's say, if the parties breach the contract, that would be an action in personam because that concerns the parties to a dispute. Whereas an action in rem is exercisable against world at large. Now, in the instant case, the arrest of vessel is an action in rem, as the ship is a judicial personality, and the same was held.
How it comes under action in rem, because it is a violation of the contractual obligations. It is just between the owner of the vessel and the charter party or the carriers. Then how it comes under action in rem? Is it action? Is it actually action rem, or is it exercised in these circumstances?
Your lordship, action
Simply
in rem
substantiate
per
that.
se is, if your ladyship could come again.
Okay, continue. I just said, please substantiate that point once again.
Indeed, your ladyship. Now, your lordship's, an action in rem is a type of lawsuit which is brought against a piece of property itself instead of the owner of the property. Now, herein, the action in rem is brought against the ship itself, which has a judicial personality, meaning thereby that it has a legal status. Now, this legal status can be claimed by any person at any point of time, as opposed to an action in personam, which is between two parties, which is against a person, an individual. And the action in rem, as held in Booz Allen case, is non-arbitrable. And this is what the council is trying to contend. The same has been affirmed in various judicial pronouncements over the years. Booz Allen, A. Swami case, Vidya Drolia case.
Yeah.
So this is what if that answers your lordship's question.
Yes. Please carry on.
Much obliged, your lordship. Furthermore, in the concluding remarks, the council would like to again emphasize that even in the presence of a mutually decided arbitration between the parties, a dispute matter related to an action in rem will be considered as non-arbitrable, and the same was held in A. Ayasamy versus A. Parmasivam. Thus, the council contends that the present dispute that relates to the arrest of vessel, which is essentially an action in rem, is non-arbitrable. If your lordships do not have any further question, the council seeks permission to proceed to prayer.
Yes, please go ahead.
Much obliged, your lordship. In the light of the issues raised, arguments advanced, may this honorable court be pleased to adjudge that the exercise of admiralty jurisdiction, despite the presence of an arbitration clause in the charter party, is valid. Declare that the general average is legally unsustainable if the vessel is unseaworthy. Declare that the sanctions of the third country cannot be enforced by this court while considering this issue. And declare that the rival claims cannot be adjudicated upon by this court even if the alleged damage occurred within its territorial waters. And the Arbitration and Conciliation Act exclude an action in rem from its purview as non-arbitrable, and pass any other order which this honorable court may deem fit in the furtherance of equity, justice, and good conscience. And for this act of kindness, the petitioners shall as in duty bound ever pray. Lordship, may the present council also add that it indeed was an absolute privilege to plead before this honorable court.
Yes.
Much obliged, your lordship.
So if the lordships are ready, I would like to invite the first speaker for the respondents to speak.
Please.
Yes.
So speaker 1, IMC 114, your time starts now.
Your Lordship, if I may please your Lordship, may I
Yes.
proceed with the fact in brief, your Lordship? Am I audible, Lordship?
Yes, you are
Yes,
audible.
counsel. Yes, counsel.
Okay. May I proceed with the briefing of the facts, your Lordship?
Please.
Must oblige, your Lordship. Lordship, here the claimant is the Octa Limited, an AU-based company. They time-chartered our party's vessel, MV Moonlight, flying the flag of Indo for the purpose of transportation of cargo from Kingdom of AU to West Coast of Indo, your Lordship. The vessel is in current situation at the Dayal port. And on 19 May 2021, there was a clean fixture between the two parties on the charter of the vessel, your Lordship. Thereafter, the claimant directed the vessel to sail to Fujairah for the bunkering purpose. The charter party was entered in an NYPE form, and the NYPE clearly states that the general average issues will be dealt by the rule of your conduct rule, your Lordship. And after that, on 8 July 2021, based on the update received by the Octa Limited, your Lordship, that the respondent's party, the vessel owner, informed the party that the cargo of 650 metric ton was to be jettisoned due to the bad weather condition that the ship was suffered. So the jettison was informed to the Octa Limited company on time. And after that, after reaching the port, there was an issue of short delivery and the general contribution. When the general contribution was declared by our party at the owner of the ship, your Lordship, there was an issue.
What are the procedure to be followed if a cargo to be jettisoned?
Your Lordship, a cargo in the middle of the sea will be jettisoned if the vessel is suffering from kind of difficulties or dangers. Your Lordship, if I may explain that, the vessel is in the middle of the sea. There will be a lot of difficulties and a kind of bad weather, and the seas dangerous and dangerous behavior in sometimes due to the weather. The ship owner will have to take a decision, and at that time, the decision was to be taken on the jettisoning of the cargo due to the 35-degree listing of thick ship to the starboard side.
I'm sorry, is it the owner of the vessel to take the decision, or the captain of the vessel to take the decision to the cargo to be jettisoned?
Your Lordship, it is the duty of the captain. Indeed, the charter party agreement clearly states that the charter party means the Octa Limited Company here will have the entire ruling authority during the time of the charter party. So even though the captain and the crew is under the ship's owner or the ship owner's workers, but the directions and the rules and the other things will be given by the Octa Limited. So, Your Lordship, that's why the party informed the jettisoning. May I proceed to the first issue, Your Lordship, if I may please you?
Yes, before that, here, this ship itself is unseaworthy. So
Yes.
how can the procedure of jettison can be exercised? Because the ship was not supposed to go for a voyage.
Your Lordship, I beg your pardon. I didn't get the point you're trying to make, Your Lordship. Can you repeat, please?
In this case, the ship itself is unseaworthy. It's clear, right?
Your Lordship, I'm afraid that I should differ with your opinion, Your Lordship, because the ship wasn't unseaworthy, Your Lordship.
Okay. So the jettison can be exercised only to save the vessel, right? Only to save the vessel or the crews of the vessels, right?
Your Lordship.
Here, yeah, please.
Yes, Your Lordship. You may continue. Your Lordship, yeah.
Carry on. What is the
Thank you. Much obliged, Your Lordship.
Yes.
The jettisoning of a cargo is normally carried out to save the entire ship, the entire cargo. And Your Lordship, you may know that, thank me, that there will be a lot of cargoes of different owners. And to save the entire cargo, there should jettison some amount of cargo in such situations. That's what the captain did, informing the Octa Limited in due time, Your Lordship.
That's true. Is there any criteria or procedure that captain should choose the particular cargo to be jettisoned? Is there any such procedure, or is there any such criteria to be followed by the captain of the ship?
Your Lordship, for the part of particular criteria or particular choosing of the particular cargoes, there is no mentioning of such particular choosing of the particular cargo. But Your Lordship, there is some criteria and some situations that the captain should take into consideration while making a decision on jettisoning. Your Lordship, the captain should jettison only if it is necessary for the common safety, Your Lordship. It is mentioned in York and Red Rule. York and Red Rule is a kind of rules which is related to the right and obligations of that arising out of this claim of general average, Your Lordship. So when the captain makes a jettisoning decision, he has to consider four things. That firstly, it should be for the common safety, it should be voluntary, and it should be in the middle of the sea. And Your Lordship, I beg your pardon, I remember not the fourth point, Your Lordship. So there are criteria, Your Lordship.
Okay, carry on.
Thank you. Much obliged, Your Lordship. I am proceeding to the first issue of Your Lordship with your permission. If I may satisfy you.
Yes, please.
Yes.
Much obliged, Your Lordship. In view of the arbitration clause in the charter party, the exercise of the admiralty jurisdiction by the court is not valid. It's a contention of this council, Your Lordship. Your Lordship, the charter party agreement is in NYPE. Properties exchange is a kind of time charter party agreement, which naturally the ship owners and the merchants are taking into consideration while making charter party agreement. Your Lordship, in NYPE clause 25, it's clearly mentioned that any claims in relation with the general average should be dealt with and should be governed by the York and Red Rule. And in York and Red Rule, it is clearly mentioned that the charter party, the general average issues should be dealt by the arbitration in London, which is in Lloyd London, Your Lordship, to be clear more. So, if any dispute arises under this charter, general average arbitration in London to apply, one to be appointed by each of the parties here too. That means the procedure of the arbitration in London, Your Lordship. So, Your Lordship, to be clear in this matter, there is a NYPE form charter between these two parties. And to add to more, furthermore, Your Lordship, there's a clean fixture, which is mentioned in the fact, Your Lordship, that a clean fixture means, Your Lordship, that after entering into the charter party agreement, no addition and no removal of any kind of articles or any kind of rules should be made. That's what the clean fixture means. So, Your Lordship, with clear intention and with full belief and in good faith that the Octa Limited, who is the petitioner here, Lordship, has entered into clean fixture, not only into charter party, they entered into clean fixture, Your Lordship. So there is no chance of deviating from the clean fixture. That's what the clean fixture means, Your Lordship. If they ask to proceed with the case in India, in this court, not going to the arbitration, Your Lordship, I'm asking that by arresting the ship, by arresting our ship, the respondent party's ship, Your Lordship. So what's the point of entering into the clean fixture? That's a question that should be answered. So the clean fixture actually means no addition and no removal of any kind of rules or regulations that's been entered in the NYPE form or any charter party agreement. So that's why this council argued that, Your Lordship, this court has no jurisdiction to make this, to allow this petition in view of the arbitration clause, Your Lordship. If I may satisfy Your Lordship, may I move on to the second issue?
The arbitration clause is based on party autonomy, right?
Yes, Your Lordship. Indeed, Your Lordship.
Yes. So the parties can choose the arbitration to be conducted any countries, right? Any of the countries they wish, or any of the forum they wish, any private arbitrators?
Your Lordship, they had a choice, but according to the charter party agreements, it should be in London and Lloyd.
Okay. If an arbitration award is binding to all the courts of all the globe or anywhere, it is binding, the arbitration award is binding?
Your Lordship,
can be binding to a court, established court, like is it a binding, if, for example, the parties entered into arbitration with a private arbitrator, whether it is binding to the courts?
Your Lordship, if the I hope that Your Lordship are making the point that whether an arbitrator award that's awarded outside the country is binding on the courts of India.
Yes.
It's obvious, Your Lordship, that nothing out of the state and is binding upon the Indian courts, and including the arbitrator award. But as to coming to back to the fact, Your Lordship, here the question arises whether the arbitration clause existing the arbitration clause impedes the procedure of admiralty jurisdiction in India in the High Court of Mumbai. Your Lordship, for the contention part, this council argues that the arbitration clause is valid. It should be valid. That the clean fixture is here, Your Lordship. Clean fixture means no addition, no removal of any rules. So the Octa Limited, the petitioner here has entered into that clean fixture with good faith, that with no force, Your Lordship. So they have to comply with it. And the court would consider, we hope, the court would consider this matter. In fact, if I satisfy Your Lordship, may I move on to the second issue?
Please.
Much obliged, Your Lordship. The declaration of general average is legally sustainable. Your Lordship, here the seaworthiness and the unseaworthiness of the ship comes into this discussion. The charter party was entered in NYPE form, the section New York Produce Exchange form, Your Lordship. The section 25 of NYPE form clearly states that any disputes relating to and any matter relating to the general average should be dealt by and governed by the York Conduct Rule 1994. So, Your Lordship, York Conduct Rule second states that the loss or damage to the property involved in the common maritime adventure by or in consequence of a sacrifice made for the common safety. Your Lordship, I'd like your attention to this matter, to this word itself, common safety. Any matter, any loss consequence of a sacrifice made for the common safety, and by water which goes down a ship's hatches opened or other opening made for the purpose of making a jettison for the jettison, your Lordship, for the common safety shall be allowed as general average. It was for the common safety, your Lordship, that the ship has to
Not audible, counsel.
Counsel? I think he left. Did he leave?
Court officer.
Court officers?
Yes, ma'am. He has joined back now.
I beg your pardon, your Lordship, that was a technical issues there.
Please, please.
May I continue, your Lordship?
Yes,
Okay.
please.
Much
Yes,
obliged.
yes.
So, your Lordship, as I have been reading the memo, making a jettison for the common safety should be allowed as general average. It was for the common safety, your Lordship and Ladyship, that the jettison was made, because, Lordship, the ship was listed to 35 degree to starboard side. If the rudder of the ship becomes 35 degree to the starboard side, it is highly dangerous according to the technicality of the ships, of the vessel, seagoing ships, your Lordship. So it is dangerous that the ship is in great danger. That's why the ship has to, the captain has to jettison 650 metric ton of methanol. And your Lordship, it was made in following the octal limit. So there is no kind of breach of contract or anything things happened. And your Lordship, I would like to invite your attention to the backside of the fact that the NYPE form is there. NYPE, the charter party, the time charter party agreement was entered in NYPE form. And in NYPE form, section 25 clearly states that any matter relating to the general average should be dealt by New York and Webb rule. And your Lordship and Ladyship, it's clearly mentioned in York and Webb rule that any matter relating to the common safety, any jettisoning for the common safety should be allowed as general average. So it is clear that according to the charter party agreement itself, the general average claim is considerable, is sustainable, your Lordship and Ladyship. So that's all in the issue second, your Lordship and Ladyship. If I may satisfy you, I'll move on to the third issue.
Anything related to unseaworthiness is mentioned?
Yes, your Ladyship.
Okay. Counsel, anything related to unseaworthiness is mentioned anywhere in this rules?
Your Ladyship, unless is mentioned, yes, some kind of vague mentioning is there in your conduct rule, your Ladyship, but there is no specific mentioning. But I believe that I can give you, your Lordship, that kind of hint to that matter, if I may, if you allow me, your Lordship, to that matter. That's unseaworthiness and seaworthiness is determined. Your Lordship, we know that that ship is a huge and big vessel. So the checking of the vessel at the time of entering into the charter party is difficult. So actually and normally, all the charter parties are determining the seaworthiness and seaworthiness of the ship based on some certificates, your Ladyship. And the certificates will be provided by internationally acknowledged parties and parties and organizations like SOLAS, Safety of Life at Sea and Ship. Your Lordship, there are some kind of certificate and some kind of test is the steer wheel test is also there, your Ladyship. So after time of entering into the charter party.
Yes, who is the authority to give that certificate and seaworthiness certificate in India? Who will examine the ship? And who will award the seaworthiness? Who is the authority in India to provide seaworthiness to your ship?
Your Lordship, I'm afraid that I can't answer that question. I should read, I think so. I beg your pardon.
Yes, please go ahead.
If I satisfy your Lordship, may I continue with them?
Yes, please.
Much obliged, your Lordship. And for the part, the charter, when entering to the charter party agreement, all the ships throughout the entire world will provide with the certificates at the time of charter party. And our respondent, this council's party, that's the respondent here, your Lordship, had also provided with the certificate. That's obvious, your Lordship. So the ship was at the time of beginning of the voyage, the contention that the ship was unseaworthy is not, it's not sustainable, your lords, because if the ship was unseaworthy, why did the petitioner's party did enter to the contract with us, with the party? That's the question, your lordship. And yes, it is the duty of the ship's owner to make it unsafe, to make sure that it was seaworthy, and it also, there is also an obligation on the party that to make sure that it was seaworthy. So their obligation will be carried out by seeing the certificates and be provided with the certificates, your lordship. And after that, your lordship, there's another matter that I would like to invite your attention to. That there was a clause that
you are arguing that if a ship owner or a vessel is seaworthy, if that owner carrier enters into a contract, that is an implied meaning that that is seaworthy, right?
Yes, your lordship.
Okay, if a carrier enters into a contract, that itself clears that the ship is seaworthy. Here, in this matter, he enters into a contract, but the ship was unseaworthy, right?
I'm afraid, your lordship, that I should differ with your contention.
Yeah,
the lordship.
Yeah.
Your lordship, the point I'm trying to make is that throughout the world, when a charter party enters into a contract with a vessel, they would normally check the certificate, the seaworthiness certificate of the ship. And as per the rules and regulations of each country, the ships should have the certificates. So we know that even though it is not mentioned in the fact, your lordship, we are in good faith and in good belief that the ship provided with the certificates. That's why the Octa Limited entered into the contract with the ship, charter party ship. Your lordship, after that, there is another matter, your lordship and ladyship. I would like to invite your attention to that. There was a clause that the ship do not vessel go into the war zone. And even after making such a clause, the Octa Limited, who is the charter party, and the charter party means they have the full direction of the ship. Even the crew and the captain of the ship is belong to the owner. The direction should be given by the charter party, and they directed our party, that the ship's crew and captain, to go into the Iran, which was politically unrest at the time. So your lordship, in the fear of breaching the contract or making the contract void, that the captain had to go to the Iran. So your lordship, we think and we believe that going into Iran was and directing the ship to go to Iran at that time of political unrest was a major mistake from the part of the Octa Limited. And the political unrest means a lot of things. So the ship may have injured at that port. It was totally the responsibility of the petitioner, your lordship. And even after coming back from the BIK to the Indo port, your lordship, they suffered from bad weather. And the ship listed into 35 degree. And according to the technicalities, your lordship, 35 degree, listing of 35 degree is abnormal, and it is not good for the safety of the ship, and it is very danger. That's why the ship captain has to decide on the matter to jettison the 650 metric ton of metal. If I satisfy your lordship, may I deal with the third issue?
Yes, if a captain decides to jettison a cargo, is there any procedure to be followed by the captain? Should he inform the owner of the ship? Should he inform charter parties or any of the person? I mean, any of the parties to the contract? Should he inform that is he's going to jettison this cargo, a specific cargo?
Your lordship, yeah, I'm glad that your lordship asked that question. Your lordship, that it is not there that the ship owner should inform this charter party, and because it is the time charter party, that's NYPE firm, your lordship. And in NYPE firm, it's clearly mentioned that the general liability should be dealt by your convoy crew. And in your convoy crew, your lordship, it's clearly mentioned jettisoning of cargo for the common safety should be considered as general average. So
captain, yes, so captain can decide. That is his discretion to jettison any of the cargoes on board without communicating with the owner of the vessel or to any of the parties, right? He can decide.
Your lordship, he can decide on the, but it is not an absolute right of him. Your lordship, he don't have to inform the charter party, because the charter party was entered in a form that which mentions that he can jettison if the necessary condition arises upon the basis of necessity and need, your lordship. Yes.
For
Your
example,
Lordship.
a ship contains edibles like vegetables, seafood, oils. So, how can a captain know that which cargo should be jettisoned? Or, for example, chemicals also there. Some, for example, vaporizers or some kind of chemicals. So, how can a captain decide which cargo must be jettisoned to save the ship?
Your Lordship, it would be totally based on the.
I'm saying, yeah. For example, seafoods. For example, it may be perished very soon. So if it is kept on board, the other goods also may be perished. And what is there any criteria? That is my question again. Is there any criteria to be followed by the captain that a cargo to be jettisoned?
Your Lordship, as answering your question, Your Lordship, that for the part of criteria, I didn't see any criteria to the part of any choosing of the particular cargo. For the part of vegetables and that you asked, Your Lordship, or the other cargos, I think, Your Lordship, it is totally based on the personal or the specific and special circumstances that would arise. The vegetable is
without interrupting the court, with the permission of the Lordship, let me rewind that the speaker, your time is up. We have exceeded the time by around 9 minutes.
Yeah, please let him finish, please. I asked more questions anyway.
Yes, Your Lordship.
Your Lordship, may I briefly mention the third issue?
Yes, please. Go ahead.
Much obliged, Your Lordship. The court, considering the issues bound by sanctions imposed by a third country, Your Lordship, the insurance granted for the general average to the party, to the vessel by the insurance company, which is blacklisted in SDN list, specially designated nationals, which is published by the OFAC, Office of Foreign Asset Control of America, Your Lordship. So it is clear that we both believe that the Indian courts are not responsible for the OFAC publications or any blacklist. It's not binding upon our courts. Yes, Your Lordship, it is clear. But the vessel is an international sailing ship, Your Lordship. So they will have to confront a lot of contracts from all over the world in the future. So the Octa Limited made the vessel owner in contract with an insurance company which is blacklisted by the Office of Foreign Asset Control of America. So in the future, it will affect, Your Lordship, the future contracts and future dealings of the vessel. So Your Lordship, even though the courts are not binding on the sanctions of the America, which is the third country here mentioned in the fact, Your Lordship, we kindly invite Your Lordship, your attention to this matter. It is a great danger to the vessel, to our party in future contracts. That's it, Your Lordship. If I may satisfy you, my co-counsel will deal with the rest issues.
Yes, please.
Much obliged, Your Lordship.
Welcome, sir.
Your Lordship, there is a few technical snag here. I hope you will consider it.
Yes, counsel, please.
Your Lordship, am I audible?
Yes, echo is
Yes.
there. You are audible. You're audible. Echo, kind of echo.
Much obliged, Your Lordship.
Echo. Yes.
My please this honorable call. This is the counsel on behalf of respondent in the instant case. I'm handling with the fourth and final issue. Your Lordship, may I move to the further arguments?
Please.
Much obliged, Your Lordship. The court can adjudicate on the claims, notwithstanding the fact that the alleged damage occurred within its territorial waters. It's clear from the fact that the charter party and the owner of the ship, entered into a clean fixture. So, among other things, called for all disputes between the claimants of charters and owners to be resolved through arbitration in London. So as per the NYP form was used to enter the charter party section 25 of which explicitly states that the general average should be adjusted as per York and Rules 1994. Any disagreements over general average must be decided in arbitration at Lloyd's, London, according to the York and Rules 1994. Therefore, any proceeding pertaining to the adjudication of the issue should take place only at the place that the parties to the charter party agreement has agreed upon. So it's clear that here there is no any claim exists in the court. So there is no evidence from the fact that giving that any other claim is existing in the court. So the court cannot adjudicate on any other claims, and there is no such claims existing in the court. So it's very clear that the court cannot adjudicate on the claims, notwithstanding on the fact. So this is our argument. Your Lordship, if there is no any further doubt, can I move to the next issue, Your Lordship?
Okay, please carry on.
Much obliged, Your Lordship. The final issue the council deal with, the provision of the Arbitration Act not exclude an action in rem from its purview as non-arbitrable. In the case fact itself, it's clear that if there is any disputes arise between the charter party or the owner of the ships, everything should be discussed only within the arbitration as per the New York and rule. So here, the issue is raising that the action in rem from its purview as non-arbitrable. But here, right in rem, here it is clearly understood that it is the right in personam. So the right in personam is arbitrable. So I bring with some case that was held by Supreme Court in Bose Allen's case stated that the dispute relating to subordinate rights in personam arising from rights in rem have always been considered to be arbitrable. And also there is a judgment from Bombay High Court in the case Eros International Media Limited versus Telemax Links India Private Limited and others. In this case, the Bombay High Court has held that the overlaying copyright is a right in rem enforceable against the world at large and it is arbitrable. Therefore, some disputes in a relation with an action in rem are qualified for adjudication and settlement by arbitration. Hence, it's humbly submitted to the Honorable Court to address the issue is arbitrable and it can be discussed as per their clean fixture, as per their agreement. The issue is arbitrable and it's not a right in rem. So it can be the dispute can only be finished as per their clean fixture, that is from Lloyd, London. If the issues are clear, Your Lordship, may I move to the prayer?
Yes, so your argument is that the action in rem is not arbitrable, right?
Indeed, Your Lordship.
Okay. Yes, carry on.
Your Lordship, may I move to prayer?
Yes, please.
Wherefore, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Honorable Court may be pleased to find that in view of arbitration clause in the charter party, the exercise of admiralty jurisdiction by the court is not valid. The declaration of general average is legally sustainable since the vessel was unseaworthy. The court, seaworthy. The court, considering the issue bound by sanctions imposed by a third country, the court cannot adjudicate on the claims considering the fact that the alleged damage occurred within its territorial waters. The provisions of the Arbitration Act not exclude an in rem from its purview as non-arbitrable and pass any such order that this Honorable Court deem fit in the interest of justice, equity, and good consent.
Yes.
Much obliged, Your Lordship. It was a good time to deal with you, your Lordships.
Yes, Counsel.
Much obliged.
So if the lordships are ready, the team IMC 113 may start your rebuttal. You have 2 minutes for rebuttal.
Yes, yes, please.
Lordships, with utmost humility and respect, the council would like to draw your kind attention towards what the respondent has contended. That due to the clean fixture mentioned in the charter party, the claimants were not supposed to send the vessel to an unsafe zone. However, your lordship, since the charter party is in an NYPE form, according to clause 34B of NYPE, the owner has the right to refuse to proceed to the loading or discharging ports in a situation, and they shall immediately inform the charters. Your lordship, in a situation where the charters are sending the vessel to an unsafe zone, the ship owners have complete authority to refuse the contention. And in such a case, the cargo cannot be discharged unless and until the cargo owners agree to it. Your lordship, in the
Excuse
instant
me,
case,
counsel. We are facing some difficulties and we will lose our connection within minutes. So if your lordship allows, please give few minutes.
Yes, please, Karen. Please conclude.
So,
Yes.
very sorry for the inconvenience. Please, we will lose our connection within seconds. So we will reconnect it within few minutes. Can you please allow that, your lordship?
Court officer?
Court officers.
Yeah, in case of any difficulty, yeah, we could allow it, but then yeah, could we make it fast? Because we have already
Okay.
exceeded the time.
Thank you. Thank you. We will join soon.
Okay. So the rebuttal session is resumed, right? Please conclude. Yes.
your lordship, the council should continue with the battle round.
Yes, please.
All right.
Yes.
So, according to your lordship, in the instant case, the vessel moved to the unsafe zone with the permission of the ship owners. They had complete right to refuse it, but even though they agreed to it, and the vessel was proceeded towards an unsafe zone. Your lordship, secondly, according to a clause NYP, vessel delivery shall be seaworthy, and your lordship, the council just seeks a moment.
Yes.
Your
Yes.
lordship, yes, your lordship.
Yes, continue.
Your lordship, the respondent contended that during the time of the agreement, certificates are provided to show the seaworthiness of the vessel. However, the facts of the case are silent upon this fact, and that's a far-fetched argument. It's just an assumption that the defendants have made, and we would like to request the defendants to apprise the court with some substantial evidence. Your lordship, ship owners are obligated to deliver a seaworthy vessel at the time of the agreement of the parties. And your lordship, in the instant case, the jettisoning of the cargo was due to the bad weather. And as stated by the council earlier in the arguments, bad weather is the most expected event that is expected to happen in a voyage while the vessel in its original course. The vessel could not stand the bad weather because the ship owner did not do his part of the due diligence, which made the vessel unseaworthy.
The ship is seaworthy only because the ship may face any kind of bad weather. It is unexpected, right? So the parties to the contract should examine whether the ship is seaworthy or not. Is it mandatory to the parties to examine the seaworthiness of the ship?
Indeed, your lordship. Your Lordship, if the vessel is unseaworthy at the time of the commencement of the voyage, that is in breach of Article 3, Rule 1 of the Hague-Visby Rules, which clearly
Yes.
states that the ship owners are obligated to provide a seaworthy vessel to the charterers.
Okay, so my question is that not only the ship owners, but the parties to the contract also should make sure that the ship is seaworthy.
Your Lordships, there have been no the facts of the case are silent on the fact if the certificates were given to the charters.
Yes, please.
That's all, Your Lordship.
Okay. Court officer?
So if the lordships are ready, we could proceed with the rebuttal of IMC 114. The speaker one had exceeded the time by 10 minutes, so their rebuttal is reduced by 5 minutes because the speaker two had reduced their time. So they are awarded a total rebuttal of 6 minutes.
Yes. Yes. Please go ahead.
With your permission, Your Lordship.
Yes.
Your Lordship, the land opposite counsel contention is that the ship was unseaworthy. If the ship was unseaworthy, then the responsibilities is on the owner of the ship. Yes, Your Lordship, we agree to that point that if the ship was unseaworthy, the responsibility will come upon the owner of the ship. But Your Lordship, upon what basis are they making the point that ship was unseaworthy? They didn't bring any kind of proof to prove that the ship was unseaworthy at the time of the beginning of the voyage, Your Lordship and Lordship. And to add to that point, Your Lordship, why did they enter into the contract if the ship was unseaworthy? That's a question that should be addressed, Your Lordship. And to add further, Your Lordship, the ship, upon their direction, went to BIK Iran, Your Lordship. There was a political unrest condition, and knowing that, they directed the ship to go to that place. Your Lordship, after entering into the charter party agreement, it is the full control of the charter party, which is Octa Limited here, to direct the ship, and they directed themselves to the ship to go to the BIK Iran. So they should consider that matter in consideration. So if the ship has got any damage, it should be done. It should have happened in BIK Iran. Then the responsibility is full upon the charter party, who is the Octa Limited here. Your Lordship and Lordship, I would like to invite your attention to that great matter that the ship went to Iran upon their request, and that not request, Your Lordship, I beg your pardon, it's their direction, was their direction. And Lordship, to add to that, the third issue, they said the SDN list and the OFAC SDN list, Your Lordship and Lordship, it was a local declaration. No, Your Lordship, it is an international blacklisting of companies and persons and nationals according to and by scrutinizing their funds and whether they are contributing to narcotics and terrorist activities. So the OFAC list, which is SDN list, Your Lordship and Lordship, is worldwide considered by a lot of companies and a lot of organizations and nations, Your Lordship. Even though it is not binding upon Indian courts and Indian government, it is considerable in the future of this vessel. If the Octa Limited has already made the vessel owner come into the contract to that insurance company, which is blacklisted by the America. Your Lordship, you know that the soft power of America upon the world economy, Your Lordship and Lordship. So if America publishes a blacklist and this international voyaging ship comes into contract with a company which is blacklisted by American agencies, this ship's future contract and future dealings will be in grave danger. So I'd like to invite your attention, Your Lordship, to that matter also. So as the petitioner, our land opposite counsel has argued, it is not a local and not considerable blacklisting or the publication of a third country or sanction of a third country, Your Lordship. It is considerable, and it is in a position that should be considered by Your Lordship in dealing with this matter. Your Lordship, and to add to the point of due diligence raised by our land opposite counsel, the ship owner didn't make his efforts to safeguard the ship and without any valid proof, didn't take due diligence. But I would like to raise the question, Your Lordship, what is the meaning of due diligence, and upon what basis they are making the point that the captain of the ship didn't make the due diligence, the efforts to safeguard the ship. What he actually did was to safeguard the entire cargo, unless he did the jettisoning of the 650 metric ton methanol in the middle of the sea, the entire cargo would have gone to under the depth of the sea, Your Lordship. So that's a great point that Your Lordship may take into consideration.
Yes.
Okay.
Your Lordship, if I may satisfy Your Lordship,
Yes.
with your permission.
Court officer.
So with the permission of the court, let me inform the team that it is time for tabulation. So the teams may please leave the court for
Yes.
further instruction, and the team managers may please remain.
Yes.
So all of the participants can now leave the